Is the First Amendment basically decided, or is the envelope still being pushed on First Amendment?
Well, look at Citizens United. That was the the campaign finance case. I mean, all this stuff is always in flux. Sometimes it expands. Sometimes First Amendment law is much more mature. Obviously, First Amendment law has been going through the whole 20th century. I mean, the first real First Amendment case the United States Supreme Court heard was in the 30s, I guess. So it's a much longer history of that. Lots more cases, but it's the same thing. That's how it worked. I mean, you had a case dealing with libel. You had a case dealing with newspapers. You had a case what about radios? What about now you have bloggers. Do bloggers have the same kind of rights as a traditional newspaper?
Constitutional right that has been basically beaten to death, and there's nothing else to discuss.
I don't think so. I mean, there's always something to say about it. There's always some new scenario. And by the way, there also, sometimes it rolls the other way. Sometimes, in the 60s with the Warren Court is where you saw criminal procedural protections expand very dramatically. The exclusionary rule for the Fourth Amendment, all sorts of things that you didn't see before. Sometimes that stuff gets rolled back a little bit. Sometimes, things change and the composition of the judiciary changes, and judges say, you know what? The courts went too far here. This is not what the Fourth Amendment means. The Fourth Amendment does not require X, Y, and Z, and suddenly you see a case that rolls it back. So, it's an ongoing process. I don't know that there's, any area of constitutional law that's been exhausted.
Well, we can't quarter troops in our house.
Right. The Third Amendment law is very, very well developed. Anyone else?
I think there was a question over
Sure.
Yeah, just a quick question. This gentleman brought up a very good point, and it made me think about something. The problem I have with reasonable gun control laws is they're never reasonable. For example, 1 gun a month can easily become 1 gun a year, which can become no guns a year. An assault weapon, what is the definition of an assault weapon? You hear various arguments on that. So I think, at least from my standpoint, there is, and I'm probably going to get laughed at by the audience, I don't know if there is a reasonable gun control law. You mentioned RPGs, flamethrowers, things like that. But if you're talking about, let's say, handguns, or you're talking about rifles, or something along those lines, I really, really wonder, and I think a lot of gunners may agree with me. I don't want to speak obviously for everybody, but I really don't know at this point if, with the past history and what you've just argued, in how did the Second Amendment become looked at as a collective right and not an individual right? I thought the Bill of Rights were individual rights. Maybe you want to comment on that, how it became a collective right. I think that is the biggest problem that I have with reasonable gun control laws.
Well, it's two good questions. How did it become a collective right is, I guess, it's a good question. When some time ago, I went back, because I was curious myself. I went back a number of years ago, I went back and read a whole bunch of cases from the 30s and 40s. The Supreme Court has, as many of you may know, the Supreme Court has had a Second Amendment case before it. Prior to Heller, it was United States versus Miller in the 40s. And the problem with that case, it's kind of a weird case actually. The defendant wasn't there at the Supreme Court. It was just the government, and so you get bad law when you have only one side arguing it. And it was a sawed-off shotgun, and the Supreme Court didn't have a record before it about, so it's a terrible case, and the writing is so cryptic as to what they mean by it, and it's probably because you didn't have lawyers arguing back and forth. The adversary system that we have, the legal system we have is actually so much better than a lot of what some other countries do. What we have is the adversary system, where you have two people on each side just duking it out like crazy. Some people are kind of offended by that, especially in criminal law. They say, well, how can you represent criminals? They're actually defendants, they're not criminals yet, but how can you represent them? And the way we do it is you have, in criminal cases, you have the government on one side, and they're going after the guy for everything they possibly can. They're going to throw him in jail forever, regardless of what he did. And then you have the defense lawyer fighting back, and they're pushing back and forth, and hopefully somewhere in there, you get to the middle. So the Miller case is kind of ridiculous in the sense it's completely absent. It's just basically the government's brief, and the Supreme Court had to sit there and say, well, okay, so this is what the government says. I haven't heard from Miller. I have no idea what to do with this. And right around that time, there were a whole bunch of courts in the federal system that heard these things. There's a case that came from the First Circuit, which is New England. called Cases versus U.S. That's the first case that I found that in the federal system, in the Federal Court of Appeals, that came out and talked about the collective right and the militia. And everybody just followed them. If you look at the case law, everybody cites that Cases versus U.S. case just because they're just not interested in doing the hard work. That's why I talk about the scholarship and the grassroots and all that stuff. There was nothing to really base the decision on other than somebody's particular assertion as to what it means. Now that we have just reams and reams and reams of papers and symposia and other types of things to base the scholarship on and to base the decision on, you can have a 64-page opinion by Justice Scalia. He didn't do that research himself. I mean, he has law clerks and they do a lot of the research, but you know what? He also had 44 amicus briefs to pull from. In the McDonald case, I'm very proud to say that Justice Alito cited my JPFO brief in one of his footnotes, which is great. I mean, that's where the stuff comes from. It comes from the submissions of the people. So that's, to answer that question, is it just got ignored, and people just you just didn't have the fundamental base underpinnings to support the right result. Now as to reasonable regulation, I mean, that's the reason they like to call it reasonable regulation is it's really not much of a standard. It's not a good constitutional standard for deciding as to what affirmative rights you have and that are protected by the Constitution. Imagine if you could have reasonable regulation of newspapers. I mean, what does that mean? It's not a standard. It's not something a judge can look at it and say, well, is that a reasonable regulation? Well, it's subjective, but that's exactly why they like to use those words, because it doesn't mean anything, or it means everything. And that's the problem. It's standardless. And I think, the court in Heller, Justice Breyer, in his dissenting opinion, argued for something very much like that. He argued for a balancing test. Justice Breyer said, well, look, it's a very important public interest to have public safety. One of the fundamental rights of the state is to ensure public safety, to protect people from violent crime, and that type of thing. And therefore, the government should have the right to do a balancing test, balance the interest of public safety with the right to keep and bear arms, and come up with some sort of result. And what the majority wrote, and what Scalia wrote, and said, look, you don't get to make that choice anymore. That's what the Constitution does. The Bill of Rights takes that choice away from you. In enacting the First and Second and other amendments in the Bill of Rights, that choice has been taken away from legislatures. You no longer get to make the public policy decision. It's already been made for you. And so that whole idea of interest balancing and is it reasonable given the issues of crime, that decision is gone. And that's a very valuable aspect of the Heller decision. And it's actually one of the arguments that's being made in the Mueller case, in the New Jersey Carey case, is because one of the positions that has been taken by the government and by the Brady Center is that it's, there's a right to, the government has a right to protect people from the risk of people carrying loaded firearms on the streets. And, the response, one of the responses is, you know what? No, they don't. The right to protect yourself is a fundamental right that we have. You no longer get to make that choice. You no longer get to say, well, is it dangerous to carry on the street? Is it not dangerous to carry on the street? Let's weigh that against the risks of being on the street and risk of violent crime. That choice is no longer within the province of the legislature. That was taken away when the right to keep and bear arms was codified in the Bill of Rights. And that's a very important aspect of this, because if you lose that argument, then you get this. You get you get this amorphous standard that means absolutely nothing and gives you no protection.
Could I have one follow-up question?
Yeah, sure.
In regards to your arguments before the Supreme Court, my understanding is the framers of the Constitution, when using the term militia, there was no National Guard at that time. The individual people were, quote-unquote, considered the militia, from my understanding of history. Did the definition of militia ever come up in either the questionings by the Supreme Court justices or any of the arguments that you engaged in?
There's a very substantial discussion of the term militia in Justice Scalia's opinion. And actually, that's why I say it's great reading, because he parses the entire language of the Second Amendment. He goes through every word, every phrase, what it means, what it doesn't mean. And it's kind of neat when you read these cases, because, Scalia has a real flair for words. But he'll write something, and the way this works is that these justices are assigned how to, to write the opinion. They take a vote, and then if you're in the majority, if the Chief Justice is in the majority, then he says, okay, Scalia, you're going to write the opinion. If the Chief Justice is not in the majority, then the most senior justice in the majority gets to assign the opinion. So if Scalia is writing an opinion, well, then somebody else is writing a dissenting opinion. So if Scalia gets the opinion, he knows he's writing it. Stevens knows that he's writing the dissenting opinion. And they circulate drafts. And so they know what the other guys are saying. And so they're sparring with each other in the opinions. You go through the majority opinion, and then midway through, well, Justice Stevens says this, and here's why he's wrong. And Justice Breyer says this, and here's why he's wrong. And Stevens is doing the same thing. He's saying the majority says this, and this is why they're idiots. That kind of thing. That's why it's fascinating reading. And they do that same stuff with the language, with what militia means, with what keep means, bear, the people. I actually taught a class at my daughter's school. I was teaching 6th, 7th, and 8th grade. They had me as a guest lecturer in the social studies class, and it was a government class. And I was talking about the Heller case. And what I did was I brought a little display. I printed out the First Amendment, the Fourth Amendment, the Second Amendment, and the 10th Amendment, and they all use the words "the people." And I wanted to show the kids how you come up with an understanding of what the people means, because the collective right argument was saying, oh yeah, the people, it's collective right. So one of the things Scalia does in the opinion is he says, no. First Amendment, the right of the people to peaceably assemble. That's people. That's not the government or the state. That's not a collective right. That's people get to go into Times Square and rally. Fourth Amendment, the right of the people to be secure in their persons, papers, and effects. That's you and me. That's individuals. The 10th Amendment. 10th Amendment is a reservation of rights to the states or the people. Well, if the people and the states were the same thing, well, they wouldn't need to use both words. The people obviously means you and me. And so the conclusion he comes to is, look, everywhere else in the Bill of Rights it says the people meaning you and me. Obviously, they wouldn't use the same word in the Second Amendment to mean something entirely different. And that's how the opinion reads. It goes through the whole thing. It's fascinating to read. Like I said, I keep doing this, but I recommend it.
Thank you.
I was listening to a couple of arguments, and one was that police are to protect society, but they're not to protect you. And if that's the case, wouldn't it be wise for us to be able to defend ourselves in the Second Amendment? Whereas I think there was a case where 3 ladies were attacked in D.C. and they threw it out because the police didn't show up. Is that true in New Jersey?
I don't know for sure. Probably, I don't know for sure. But there's a great book written by Aaron Zellman of JPFL called Dial 911 and Die. It's all about that. He goes through all the different state laws, and he cites cases where, probably in either every state or most states, where the Supreme Courts of those states have said the police have no obligation to protect specific people. Their job is to protect society as a whole, and an individual person has no claim against the police for failing to come to their rescue. And the concept is exactly what you just said. Since the law is not designed to protect you on an individual basis, well, then there must be something else that you can do to protect yourself. And that's the argument that JPFO always made, and it kind of makes sense.